5 seconds. Start. Leave granted. These civil appeals, which have been heard through video conferencing, have been filed by three surviving dependents who are two minor daughters and father of the two deceased, impugning the judgment dated 17th July 2017 of the High Court of Delhi, through which the motor accident compensation of rupees 40 lakh 71,000 awarded by the Motor Accidents Claim Tribunal Rohini, hereinafter the tribunal, on 24 December 2016 under section 168 of the Motor Vehicle Act 1988, the MV Act, was reduced to rupees 22 lakhs. The deceased couple, Vinod and Poonam, while commuting on a motorcycle in Delhi at around 7 a.m. on 12th April 2014, were hit at an intersection by a Centro car bearing registration number DL7CA1053. The impact immediately incapacitated both the deceased, and they soon passed away from craniocerebral damage and shock caused by the accident's blunt force trauma. An FIR was registered under sections 279 and 304 of the Penal Code 1860, hereinafter IPC, against the driver, and the statement of an independent eyewitness, Constable Vishnu Dutt, was recorded, which evidenced rash driving and negligence on part of the car driver. Subsequently, a claim petition was filed under Section 166 of the MV Act by the two toddler daughters and parents of the deceased. This was contested by the driver and owner, claiming that the deceased were themselves driving negligently and the accident was as a result of their very own actions. Two witnesses were examined by the appellant claimants and none by the respondents. The insurance company respondent 1 offered as settlement a compensation of rupees 6.47 lakhs for the death of Poonam and rupees 10.71 lakhs for Vinod. The tribunal took note of the charge sheet filed against the driver in the criminal case and also his failure to step into the witness box. Relying on the strong testimony of the independent witness, it was concluded that the car driver was indeed driving rashly, and thus liability ought to be fastened on the respondent insurer. Regarding the quantum of compensation, the tribunal began by determining the ages of Poonam and Vinod as being 26 and 29 years respectively. Consequently, an age multiplier of 17 was adopted. Although the deceased father took a plea that Vinod was earning rupees 14,000 every month as a teacher at Pratap Public School in Delhi, but he was unable to substantiate his claim with any documentary evidence. Thus, minimum wage in Delhi was adopted for computation of loss of dependency. An additional 25% income was accounted for future prospects of Poonam, and one third of Vinod's salary was deducted towards personal expense. Rupees 2.50 lakhs was given for each deceased as compensation for loss of love and affection, estate, and funeral charges. Thus, the tribunal awarded a total sum of rupees 40.71 lakhs for both deceased to the claimants. This computation was challenged by the respondent insurer before the High Court on grounds that the tribunal had erroneously relied upon the minimum wage as notified by the government of Delhi, as there was no proof that the deceased were employed in Delhi. Instead, given their established residence in Haryana, the minimum wage notified for that state ought to be the basis for calculation of loss of dependency. Simultaneously, addition of future prospects as well as non deduction of personal expenses for Poonam was prayed to be reversed. Further, compensation was sought to be halved on grounds of contributory negligence. A categorical submission was made highlighting the then divergent law on the issue of payment of future prospects to non permanent employees pending resolution, of which it was prayed that no such addition be granted to the claimants. The High Court concurred with these contentions and consequently reduced the notional income for both deceased by adopting the lowest minimum wage applicable for unskilled workers in Haryana instead of Delhi. Similarly, one third of Poonam's income was deducted towards personal expenses, and future prospects were denied to both deceased. However, given the totality of circumstances and Poonam's contribution to her household, 25% additional gratuitous income was added to her salary. The High Court thus brought down the total compensation payable to the claimants to rupees 22 lakhs. This reduction has been assailed before us by the learned counsel for the claimants. Recomputation is sort of compensation for loss of dependency consequent to the decision of the constitutional bench of this court in National Insurance Company Limited versus Parna Sethi, which authoritatively settles the law on future prospects for non permanent employees as well. Furthermore, the anomaly between the graduous increase of income between Vinod and Poonam and the usage of unskilled minimum wage for Vinod have been brought to our notice. The learned counsel for the respondent insurer, on the other hand, has sought to forestall any increase in compensation, including under the ground of future prospects. It is claimed that the High Court's decision was a consent order. Stop.